Welcome to a new episode of The Law Beneath the Waves. Today we're focusing on the precautionary approach as a cornerstone of the law of the sea and contemporary ocean governance. Joined by my guests Aline Jaeckel and Keith McMaster, we explore why precaution is essential for regulating activities in the international seabed area, given the risk of environmental harm associated with deep sea activities. This episode actually takes a special and innovative angle, examine how domestic practice can and should actually inform the implementation of the precautionary approach at the international level, drawing on the fact that many states have actually already developed robust interpretation and application of precaution in their national frameworks for environmental management. This episode also examines the implementation of the precautionary approach across the entire life cycle of deep sea mining activities, from exploration to exploitation, and extending also to the monitoring phases that follow. We discuss what precaution requires in practice when reviewing contractors' plan of work, conducting environmental impact assessments, and ensuring also effective monitoring, compliance, transparency, data reliability, and independent auditing. By tracing how precaution must operate as a continuous and adaptive process, we also explore how its rigorous application can actually also strengthen governance and support institutional reform within the International Seabed Authority. This is a must-follow episode for anyone seeking to better understand the importance, scopes, and practical implementation of the precautionary approach in a deep sea mining context. Thank you very much for being here. It's a pleasure to connect with you both today. I think actually we didn't have the opportunity to meet in person, so it's actually quite nice to be able to meet virtually. And as I told you, the goal is actually to be able to provide like a different type of knowledge to support the understanding of the chapter you wrote and the understanding of the book. So you wrote actually the chapter with a different Roberts. They will not be able to be here, unfortunately, today. And maybe what we can start with is to walk through the audience through what is basically the precautionary approach. So I've placed actually the chapter that you wrote at the beginning of the book in global perspective to actually highlight the importance of this approach and how it actually is a foundational concept and approach into the law of the sea and activities that will be developed related to deep sea mining. But maybe you could start explaining what is the precautionary approach in very simple terms, and explain, for example, when and why typically this approach will be applied to the general context of natural resource management.
So I think precaution means taking environmental protection measures early. So whenever there is a risk of significant harm, to not wait until we have full scientific certainty, but to take protective measures at an early point. So there may not be full scientific certainty about, the quantity or quality of the harm, but the idea of precaution is to err on the side of caution and to sort of be better safe than sorry, I suppose, right? And so the main question then usually is, well, what protective measures do you need to take under the precautionary principle? There's a fairly simple answer to that. So any precautionary measures that are taken, they need to be both effective in reaching the environmental objective, but also proportionate to it. So no more restrictive than necessary. So it's a balancing exercise as to what counts as a precautionary measure, but they certainly have to be taken early.
Thank you. Keith, you have something to add?
Yeah, I think basically, other than that, I think it's the precautionary approach we want to say is probably now firmly established in many national laws and international laws. So I think in relatively broad terms, the precautionary approach or precautionary principle, and again, for most purposes, we're going to use them kind of interchangeably. I mean, some would argue that there are differences, but for the purposes basically of today, especially, we'll argue that they are basically, the same. The approach and the principle will be largely the same. And so I don't think there's a matter that if the precautionary approach is in a law in the international sphere or in the domestic sphere. I think often the issues are how it is interpreted, and how far and how it goes in any particular sphere.
But then you mentioned that it's the precautionary approach is actually used in case there's a lack of scientific certainties, which could be said that there's always a lack of scientific certainties. So how do you apply this approach to different type of activities, for example, fishing, or I don't know, marine scientific research or deep sea mining activities? Is there a trigger when we can consider that there's scientific uncertainty and then this approach is getting implemented? How could you explain it in the way it's applied to any type of activities? Keith, maybe?
Basically, whenever there is a large project, it'll go to the government and they will require to review the project overall. And so under the precautionary principle, basically environmental measures must anticipate and prevent and attack the causes of environmental degradation. So generally speaking, part of any plan from whether it's a developer or someone who's trying to do something is that there needs to be enough information to allow a regulator or some authority to weigh the pros and cons to anything. And generally there are, experts, scientific experts and engineering experts at, different levels of government that review a project. And so they have to anticipate it. So there needs to be enough information there. Now, again, there's generally no scientific certainty, and the precautionary principle doesn't require absolute certainty to prevent that. There would be never any projects at all if there required, scientific certainty. But there needs to be enough so that the regulator can administer the particular piece of legislation that they're doing, knowing and anticipating and filling in gaps from anything that needs to be done. And so whenever there's too much certainty, then that's when you would apply the principle to say, okay, hold off. Can you do more research, or can you fill in these gaps, or can you, pull back the activity a little bit when you're in that approval process?
It's very interesting what you say, because it means anyway, precaution is always applied. It's just a very specific level of precaution that is being required when there's certain cases of uncertainties requiring certain type of decision making and thinking and planning into the planning actually of activities, right?
Right. Yes, absolutely.
So it means, as you mentioned, it could be applied to anything from fishing to deep sea mining, depending actually on the type of activities that are being developed.
Right, absolutely. So again, often it'll be enshrined in legislation. So again, in the Canadian context, the precautionary approach and the precautionary principle are enshrined in our Fisheries Act. So anytime there's a major fisheries project, it has to go through the board. We also have our Environmental or Impact Assessment Act, and the precautionary principle is written explicitly in the legislation. In the seabed mining context, we actually have our ITLO's case, what we call the case 17 kind of deal that, on it. And again, the International Tribunal on the Law of the Sea has actually said that, precaution is also part of seabed mining and generally part of customary international law as well. And so there's other cases in the international sphere that kind of detail a little bit what the precautionary approach and precautionary principle would mean in the international context as well.
But does it mean in terms of implementation that each state is defining their own thresholds and indicators? How does it work, for example, in Canada or in Australia?
Can I just go one step back and just add to the sort of general question of, when does precaution apply before we talk about the thresholds?
Yes.
I think there's often a misunderstanding. The precautionary principle or precautionary approach, whichever terminology you prefer, doesn't apply because of uncertainty. That is incorrect. It applies because there is a risk of significant environmental harm, where it might be a risk of other type of harm. Can apply in a health context, for example. But it applies because there's a risk of significant environmental harm. and it applies in spite of uncertainty, right? Not because of it. So as you mentioned, Virginie, there is, any context includes uncertainty, certainly. We never really have full scientific certainty. That doesn't mean precaution applies to every context. So if there's a risk of harm, but that risk is remote, right? Then precaution doesn't apply. Or if the potential harm is very minor or insignificant, then again, precaution doesn't apply, even if there is a lot of uncertainty around it. So there are, thresholds for both the gravity of the harm and also the probability of it. But most importantly, there needs to be a risk of some sort of significant environmental harm. The terminology differs, whether it's serious environmental harm or significant environmental harm. But precaution doesn't apply because of uncertainty. It applies despite or in spite of uncertainty.
Indeed, and these thresholds, general thresholds are actually laid down in the UN Convention, actually in the Law of the Sea, I imagine.
No, so the Law of the Sea Convention doesn't mention precaution.
No, but it mentions the levels of protection of the marine environment with the notion of harm.
No, that's difficult because the Law of the Sea Convention is very broad in its formulation. So it requires the protection and preservation of the marine environment, but that's too broad to actually give us a threshold. But I think in the seabed mining context, the thresholds are somewhat less relevant because it is broadly accepted that precaution does apply to seabed mining, right? Mm-hmm. So it's enshrined in the ISA's exploration regulations that precaution does apply. So there's no longer a question about whether or not it does apply, whether the thresholds for its application are met. The question is more, how is it applied? What does it mean in practice?
I understand. I was actually thinking that the general thresholds of the UN Convention on the Law of the Sea, even if it doesn't specify or mention the precautionary approach, it has actually set out a level of harm that is tolerated, including through the notion of pollution and disturbance of the marine environment that is being then, digested and implemented throughout the ISA and its role of, regulating seabed mining activities. So I thought there was a sort of correlation that has inspired one with the other one, and then being more specific, in terms of the risk and the level of protection that is required for deep sea mining activities.
It depends on how you interpret the Law of the Sea Convention, I suppose. There are specific provisions that talk about the protection of flora and fauna and so on, and that certainly feeds into precaution, but there isn't a sort of specific formulation of how to apply it, I suppose. Mm. But because the ISA has included it in its mining code, there's no question of the applicability of precaution in this context.
Of course. So maybe when we hear about precaution, and Keith was actually explaining the steps that are being involved, what does it mean in terms of decision making? For example, you have a project to be reviewed, you have the scientists explaining the level of certainty or uncertainty, the risk that are associated, cumulative risk, direct risk, remote risk, transboundary risk, all the different type of risk. But what does it mean in terms of precaution, in terms of decision making? What type of decision making could be a way to reflect the implementation of the precautionary approach? Could it be quota, season closing, for example, for fishing? Could be a complete ban? Is there like a sort of kaleidoscope of measures that could be? Yes.
Yeah. Again, in the fishing context, that's great. And we just had another, a lot of our precautionary cases are based upon fishing. And so generally there will be some sort of quota or, catch limits on it. And so again, they'll be challenging. And every year there's a review based upon, updated scientific data on the level and quality of fish that are out there. So, and there might be a challenge to a specific quota, usually by a fishers group or somebody out there will challenge a decision. And so whether or not the level is challenged. Now, when you get to something like precaution, is that, courts, and this is kind of the always a difficult issue, is courts most of the time are not scientific experts. And so what level and how would you challenge based upon a precautionary approach, when you're doing a challenge? So a fishers group said, no, I don't think 1,400 kilograms of fish is enough. We think it should be X, and then you should be Y. So often you have these courts that's not scientific will often defer to an expert, or will say, will this be reasonable? What kind of threshold, rather than some sort of absolute metric, because courts or tribunals may not have the same level of scientific certainty or detail or knowledge that some of the experts. So again, often it's at least in the Canadian context, the precautionary approach is generally challenged on some sort of judicial review grounds, rather than necessarily on purely scientific merits around that. So when you talk about thresholds, it's how do you develop a threshold? Again, there's generally could be, again, in a fishing context, a lot of scientific research has said, okay, this is the right amount of fishing that will require to allow the fish to either grow or at least maintain or not degrade in terms of an annual catch. So again, that, and then of course then have to review the reasonableness of a minister or some sort of governmental officials decision making around that, rather than on a specific number or threshold, if you will.
I understand. So, for example, the decision, for example, to close completely fisheries could be challenged because it will not be reasonable in view of what could have been done. Is it what you mean, for example?
Potentially. Obviously, then generally, if there's a moratorium, we had a cod moratorium for 25 years after overfishing around that. There were some challenges, but again, there was such an urgent need at that point. But again, the review generally on every year could be like, and then so necessarily there was a moratorium. They said, do we still need a moratorium on fishing, for cod or something like that? And then so every year, then there might be challenges to review the reasonableness of continuing a moratorium around that. And what level could you start to undertake, small scale fishing or something around those kind of issues?
I understand. So it's always with the, I guess, to summarize and to extract the substance will be in a way also to balance all the time activities, economic activities, and protection of the marine environment, to be able to review this level of precaution and the measures that have been taken on the basis.
Right. Yeah. So again, that it's again, and Aline, jump in at any time to kind of fill in any gaps. So again, it depends on. So often it'll be some sort of direct or ministerial, in Canada with minister or some sort of governmental oversight and regulation that'll set kind of the rules, and then it'll be up to the court then to interpret the reasonableness of said decision, rather than necessarily the decision itself.
I understand.
Yeah, perhaps so Keith has sort of described how courts apply precaution. I could add to that how the regulators can, apply precaution as sort of at an earlier stage before, a case gets to the courts. And there's fairly good literature on all of this, of course, and it starts with setting very clear environmental goals and objectives, right? We have to know what do we want to protect, what's the aim here? And then, of course, you have to assess what are the environmental risks of the proposed activity, be it fishing or seabed mining or whatever it might be. And what we've seen in the case law is that it is absolutely key to have good environmental baselines, to sort of have a good understanding of the receiving environment before the proposed activity, because otherwise your environmental impact assessment, fails. So that's kind of the scientific task, the environmental impact assessment. And then comes the political task, and that is deciding on what protective measures you want to implement, right? And that's where we get back to this idea that precautionary measures have to be both effective in reaching the environmental goal, but also proportionate to it. And that's what Keith just mentioned, right? They have to be reasonable and proportionate to the aim. And so once a protective measure has been adopted, then we start the monitoring review phase. so that whenever new scientific information becomes available, the regulator can review the measure, be it the moratorium on cod that we've seen in Canada or any other measure, and see if it's still effective and proportionate. So as you mentioned, Virginie, there are a broad range of measures that can be precautionary. So I suppose for the seabed mining world, an example would be, if the environmental objective is to prevent loss of species, for example, if that's the objective that's agreed, then you would assess, well, what measures would achieve that? Well, not mining at all would achieve that, sure, but is it proportionate? Right, is the question. Is there a less restrictive measure that would also achieve the objective? And so you could ask, well, how about maybe just one mine site rather than several in parallel? That might be effective, but it wouldn't be if there is endemic species, for example, in that mine site, right? So you would have a species loss if you mine just at one particular site, if you have endemic species there. If, however, you know that there are no endemic species on that mine site, then maybe it is proportionate to mine in that particular area if your goal is to prevent species loss, right? So you have to have a clear goal or a clear objective, and then look at which measures are proportionate and effective, or both effective in reaching that objective, but also proportionate to it.
Thank you, Aline. I think it's a great explanation of the different steps, so people can understand actually what it means to apply the precautionary approach. So maybe we can dive now a bit more into the chapter that you wrote with Robert. So your research has been focusing on the certain Commonwealth countries, so Australia, Canada, New Zealand, and the UK, and has actually analyzed the way these countries have implemented the precautionary approach. Did you actually spot any key differences or similarities in the way these states were interpreting or implementing this precautionary approach, knowing also that this precautionary approach has not always been applied in the context of deep sea mining, because not all of these countries have faced deep sea mining cases?
Sure. I think I'd like to start by acknowledging that the chapter was lead authored by Robert McGill, who tragically passed away before the book was published, but after we had finished writing the chapter. So I think Keith and I are both very pleased to see that the chapter is out, and hopefully, what we can do here is to summarize sort of Robert's ideas, and hopefully we do them justice. So the key conclusion from the chapter is that there is a fair bit of agreement and a fair bit that can be learned from how national courts are applying the precautionary principle. So there's a fair bit of experience within national courts on how to actually give effect to precaution. And that's relevant, of course, because there seemed to have been a bit of confusion at the international level, sort of in the early 2010s, about how to apply precaution in practice. And what Robert wanted to do was to, and what our chapter hopefully achieves, is to demonstrate that actually that confusion has been largely overcome at the domestic level. Right? So domestic courts have had plenty of experience in applying precaution, as you say, not always to seabed mining, sometimes to completely different contexts, but they have applied it reasonably consistently, and that there's a fair bit of state practice that can be of help to how a precaution is applied on the international level. So we only look at 4 jurisdictions, of course, and there's plenty more. So there's more state practice beyond what's in the chapter here. But I think the main message is that at the international level, we don't have to reinvent the wheel. We do have fairly good experience at the domestic level of what precaution means in practice.
Indeed, I was thinking maybe for people who don't really know the relationship between the national and the international level, since you talk about the great lessons and practice that some states have actually developed, and I'm sure other states have developed, but they were actually beyond your reach. Maybe you could explain how the national practice and the national lessons can inform the international level, and why you created the link between the two. It's obvious for people working in international law, but for people who are actually not really aware of how the different systems interact together, I think it will be very useful to understand the value of state practice that was very, very dear to you, Robert, actually.
Yeah, happy to. So with international law, we do of course have treaty law, so codified obligations that are written down in treaties, and applying the precautionary principle is written down in many treaties, not in the Law of the Sea Convention specifically, but many other treaties. But we do also have what's called customary international law, which is unwritten international law, but no less important. And that develops in part through state practice. So looking at how domestic courts have interpreted a particular legal principle like precaution gives us a sense of how that principle might be interpreted under customary international law. So as Keith said earlier, there's a clear trend towards the precautionary principle being part of customary international law. And so looking at the domestic courts and their application of precaution helps us to flesh out what are the sort of ingredients of precaution under customary international law.
Indeed, indeed. And I think it's quite interesting also when you look at the advisory opinion of 2011 of ICLOS, saying that actually the precautionary approach was on its path to become customary international law. But now we are like more than 10 years later. So I think it will be interesting to see, you know, how your research and the research of others can actually contribute to acknowledging the really heavy weight of the precautionary approach and potentially its recognition as customary international law, because things have evolved, and I think precaution has become really a principle and approach that is really at the center of the implementation of many challenges we need to solve actually in the law of the sea and in ocean governance. So I'm actually looking forward to new cases that could actually re-examine, you know, these type of statutes a bit later. So now let's dive into something that is a bit more technical. Let's say you have, because in the sea, it's always about the activities of human, and I said like the balance with the protection of the marine environment. That is very, very important in law of the sea, this balance between the two. And so typically, you know, the precautionary approach will be trying to solve this balance, try to plan respectfully the two interests actually. But who needs to prove what? So for example, if we dive into the issue of deep sea mining, which is really the book, who will need to prove, who will actually bear the burden of the proof? Who will need to prove that, for example, science has been certain, what type of risk are there, who is assessing what? So maybe you can actually explain how the whole system with the mining code, the ISA, and the role of the state, but also the contractors in this chain, actually, of data and knowledge and risk to identify.
Yeah, I mean, seabed mining is unique in so many levels because of all the different actors and players that are involved in seabed mining, as a contrary to potentially other, because you have more states and then private actors and then government actors and then the regulator themselves. So ultimately, it is the International Seabed Authority that is tasked with, as Aline mentioned earlier, developing the mining code, which is the entire set of rules, regulations around seabed mining. We currently have, you know, 3 sets of what we call exploration regulations. And I guess we'll back up a little bit. You know, when it comes to mining, generally we separate, you know, historically the exploration phase with the what we call the exploitation phase. Exploration is basically that gathering data from a kind of scientific and commercial perspective, in the sense of, are we finding enough minerals there? Can they potentially be commercially harvested? How much, you know, how much risk is there? So it's the information gathering stage. And then from there, we jump to the exploitation, which is that commercial level mining operations. So again, we have the 3 sets of exploration regulations, without getting too technical, the different types of potentially seabed mining operations that could be done, and largely those have been done for and in place for you know, basically up towards a couple of decades before it comes to the polymetallic nodules. So again, but what we're really, and the real risk is, and so generally we've always it's been accepted that yes, there needs to be some exploration work with any kind of mining operations. And so there's been a work through around what's the precaution when it comes to exploration. again, the real risk when it comes to mining, I think, is that commercial level exploitation of it. And so that's where the Seabed Authority is currently still developing the mining regulations. So again, like you mentioned, the law of the sea is very, very broad when it comes to general aims of protection of the marine environment, but it would pretty much be the mining code and the exploitation regulations that would set out a little bit more on the technical details of what would be required from our precautionary approach principle. So basically, what are the levels of impact assessment? Basically, what information should you require? What data do you need to collect? How much certainty do you need out there? So then it should be then this Seabed Authority that is responsible for developing, and its member countries, all 167 member countries that are developing, putting input into the mining code. And then it would be on that same ISA that would then review any of the contractor data when they apply for that exploration permit or a commercial recovery license as well.
Mm-hmm. I have a small question, because the way you described it was really clear, but you linked more the precautionary approach to the exploitation phase, because you said that it was the most difficult one in terms of risk for the marine environment. But the precautionary approach applies also to exploration, I imagine. And there's been a lot of noise about, the test mining that has been done. I think it was a year and a half ago.
Yes.
How did the ISA actually apply the precautionary approach in terms of this test mining that was actually quite important? So just to explain that the precautionary approach is there each step of the way, and not we just need to wait for the exploitation to start to implement actually this very important legal principle.
Oh, absolutely. And when I said that again, and Aline kind of alluded earlier, it's when it comes to when it comes to mining, there's going to be there's a big environmental risk, and there potentially will be environmental degradation. From an exploration phase, again, it's the probability of harm times the multiplied by the severity of harm. And so that's why there is still potential for harm when it comes to research and the exploration. But certainly the amount of harm that could happen in a commercial operation would be greater. So that's kind of focusing.
Aline, you want to jump in?
Yeah, just to add to that, in terms of the test mining that was carried out a few years ago, as you mentioned, it's quite interesting that the ISA usually isn't specific or explicit about, how to apply precaution or how it applies precaution. So there were no particular sort of precautionary measures being taken at that point of test mining. The only sort of the most relevant one, I suppose, or the most relevant one is that the mining company that was carrying out the test mining had to submit an environmental impact assessment before the test mining. But the key here is that during the exploration stage, these environmental impact assessments, they only get sort of reviewed by the ISA, but no decision is made based on it. So that means the mining company already had an exploration contract that spans 15 years. And within that time, they are entitled to carry out test mining activities. Now, before they do so, they need to submit an environmental impact assessment. But there is no point at which the ISA then rejects that EIA or approves that EIA. There's no actual decision making based on that EIA, which is, problematic, and it means that the value of that environmental impact assessment is reduced.
As you both really explained super well, that the different steps of the precautionary approach implies a decision-making step also that is very clear. So that's why I was actually asking the question about test mining, because I think it's a great example of the issues that we face with the implementation of the precautionary approach with regards to seabed mining. So in the International Seabed Authority, but also, in the International Seabed Area, but also on the continental shelf, but then we'll deal with that with other authors. It's very interesting. And the main issue when I was talking about the burden of proof is, for example, if a state, for example, wants to challenge, the activities of another state, which is what we do usually in international law. It's states against states. So what will that entail actually in terms of the implementation of the precautionary approach and the challenge that could be made? Who will have to prove what? So I come back to my original question. How do you use this precaution, and how do you make it something useful, in an international case when you want to challenge an activity?
Yeah, great question. In the ISA context, I mean, we could eventually see cases, between two different states. That may be a possibility, but the sort of day-to-day application of precaution in the ISA context is more that a mining company, when they apply for an exploration or an exploitation contract, they have to, well, they don't have to prove that their work is, their operations are harmless. That's, not a requirement, but there is a presumption of harm. Right, there's a presumption of harm built into the mining code. So it's the ISA as the regulator that needs to determine whether a mining proposal provides for what they call effective protection of the marine environment. Right, so it's the ISA that's essentially deciding whether or not a mining proposal can go ahead and meets the precautionary principle or not. We haven't yet seen state-to-state dispute in the context of seabed mining. That's not to say it may not happen, but we haven't gotten there yet.
It's interesting what you bring, because I think it highlights really perfectly the two different sides. The reality of the implementation of the precautionary approach. You have, of course, the state-to-state, which is the classical, but you have also the responsibility of the International Seabed Authority, which is something also different. So in terms of kaleidoscope, you have like different avenues, in terms of implementation and challenge and of the precautionary approach. I wanted to come back to the environmental impact, because when you were describing about the test mining, you were saying that the company actually had to do an environmental impact assessment. But you mentioned very early on, before in the discussion, that there was an issue with environmental baseline information. Can you actually explain the relationship between the two? So basically the baseline is the knowledge before any activities are taking place. It's being able to understand what will be the impact on something that has never been touched, right? To make it super simple.
Yes, that's right. So it's just about understanding, at a particular mine site, what is the ecology, what does the environment look like right now before any mining, right? Because if you want to predict what the environmental impacts will be, well, you have to first understand, what does the environment look like right now? If you want to be able to measure species loss or any other habitat distraction or whatever else it might be, you first have to know, what does a habitat look like right now, or what species live there at the moment, so that you can actually then measure and monitor any species loss or habitat loss and so on. And what was interesting in our book chapter, this importance of environmental baseline information was stressed over and over again. In lots of different contexts, right? The idea is that without good environmental baseline information, you can't really assess the environmental impact of an activity. Now, that's not to say you have to know everything there is to know about the environment, before any mining or before any fishing, but you have to have a solid idea as to what is going on in that environment. And it was interesting in the case law also, that importance of environmental baseline was used to analyze whether or not adaptive management is relevant. So that's something we've seen coming up over and over again in the discussion about whether or not to apply precaution. This question of, can adaptive management be a way around precaution? Can it be an alternative to a precaution, or can it be compatible with precaution? And what we've seen here is that domestic courts have said, yes, adaptive management can be compatible with precaution, but only if a few requirements are met. You have to start with good environmental baseline knowledge. Not perfect, but solid, right? You have to know what your starting position is. Then you have to have clear and enforceable environmental objectives. So you have to know where you're going. The starting point needs to be clear and the objective needs to be clear. And then what adaptive management allows you to do is to sort of, find a way to get from your starting position to your objective, and you can adapt the operations and so on. But without those two, baseline information and your objective clearly set, you can't apply adaptive management, because you can't really measure whether your adaptive management is, going where it's supposed to be going. And the courts have also said, and I found this interesting, that you have to have a clear process for evaluating any monitoring results, right? So when changing operations to adapt your management, well, you have to have the means and technology and so on to measure whether you're doing, what you're doing makes sense. And when we look at New Zealand law, they go a step further and say that adaptive management is not available for marine pollution, for example, because that's a case where the harm is irreversible. Now, that's not the case in every jurisdiction, of course, but it's an interesting example to think about, where pollution is irreversible, which is often the case in the marine environment. You have to be even more precautious. Whereas when you talk about fisheries, there is a degree of agility, I suppose, a degree of flexibility in fisheries recovering, whereas marine pollution, once it's caused, you can't undo the damage. So there's that also to be taken into account. But yeah, to come back to your original question, apologies, I sort of went off on a tangent here. But baseline information was seen as absolutely critical in terms of assessing the environmental impacts.
And just to jump on that again with a specific contractor example, and not naming the contractor, but again, they've submitted, a lot of their arguments will be, hey, we've done a lot of scientific research since the 60s, the 70s, and 80s. Some of these baselines are known. So again, one contractor submitted the environmental impact assessment to the ISA. It seemed to pass through without a whole lot of pushback. But when they submitted the same version, because they're publicly listed on a U.S. stock exchange, the Securities and Exchange Commission, for example, pushed back hard against some of their baselines, or the lack of baselines. Again, not necessarily on the specific numbers; they're not the experts, but it's where did you get these numbers? How did you come about this? So it was actually kind of interesting to see that the SEC, the Securities Exchange Commission in the United States, which is not even a signatory to the Law of the Sea, talk about that, that's a separate issue, was actually probably the biggest proponent to push back on some of the lack of baselines, whereas it really wasn't, as Aline kind of alluded to earlier, that wasn't that big of an issue on the ISA when they're decision making. But when some of this extra data had to come to light in terms of public filings, it was the SEC that said, are you sure that that's the right baseline? Can you justify your baseline? Please provide more evidence that you've had that this is correct. You've said this in one press release, and yet, over here you have sediment plumes that are unreported. Can you explain it a little bit more? So it's interesting to see that a regulator that's not even, regulating the activity, but regulating kind of the company, actually took maybe a bit of a precautionary approach as well, knowing that, okay, when it comes to securities laws, for example, which is not directly an environmental law, push back to make sure that show that there are actually some sort of legitimate baselines, because shows the power of the baseline. We can't prove with scientific certainty that this is, the right number, but can you show that this is an adequate baseline to go forward with additional research activities?
I think this is an excellent point. I'm not surprised that the US have been pinpointing this one, because usually they do that. But I find it really interesting, because the more we talk about it, the more obvious it becomes that, of course, at the, international courts, they are not scientific experts, so they will not, question the science, but they need to take in consideration, of course, the quality of the baseline and the quality of the environmental impact assessment, the effectiveness, and the way that it's appropriate enough to be able to make a decision on the go or not go of an economic activity. And I think it's quite interesting what has been said, because, the legitimacy or the credibility of the baseline is questioned, but it's basically the contractors that are giving these data, but there's no audit or any independent way of assessing this data, which is done in other industries, for example. So it can affect actually the implementation of the precautionary approach all along the line, because if, from the beginning we have scientific data that are not being, for example, independently reviewed, then the impact assessments are being assessed on the basis of, a baseline or scientific data, the whole system can actually be completely biased, actually. So is it something that you faced you've seen in the analysis of the different practice of the states? Is it something that came up, or you didn't have time actually to dig into this?
Heath, I can't quite recall whether we dug into that in detail in the chapter, but to sort of respond to your point more generally, I think you're absolutely right that in the ISA context, or generally in seabed mining context, one of the key problems is that we do rely generally on data from the mining contractors themselves, and because the environment in which seabed mining would occur is the deep ocean, usually far offshore, that we know very little about. We don't have much independent data to sort of compare the contractor or the mining company data to. And that's a problem for environmental baseline data. It's a problem for environmental impact assessments, but it will also be a problem for any eventual monitoring and review. So at the moment, the ISA has a mandate to monitor any seabed mining activities on the international seabed, but it's unclear how it will actually do that in practice. Any monitoring would be incredibly expensive, so it's a question of funding for it. And so there's certainly a risk that the regulator would rely to a large extent on data generated by the mining companies. And there is an obvious bias in that, as you say. But I can't recall that we've seen that particular point in domestic law. Keith, please correct me if I'm wrong.
No, yeah, I think you're right. We didn't do a larger dive. I mean, a little bit in terms of the overall picture when it comes to a lot of the domestic sphere. It comes to initial public consultations, which again is large, again, transparency, I think is kind of the bigger word in a lot of the domestic context, is that public context, but monitoring and enforcement, absolutely continuous, review. So how would monitoring and auditing and of everything actually work in the seabed mining context? Would the ISA have enough funding to send its own ship probably to the deep ocean? Probably not. So again, one idea that gets floated is, sending ISA representatives or some sort of independent representatives on contractor mining ships as well. Again, sometimes that's not permitted, or to review the data. So again, how do you monitor the data in a transparent, accurate way? How do you, audit any of those kind of reviews? Again, that's a little bit different in a domestic context. So again, in a fisheries context, in the Canadian fisheries context, well, you have the Department of Fisheries and Oceans. Here you have potentially the Canadian Coast Guard, but still, even that, there's limited data. Again, reviewing some of the data, but again, you have a very large industry in a large country that has some of the technical and financial capabilities of doing some review and monitoring. Is that present in the seabed mining context? That that remains to be seen, but potentially doubtful. But again, how do you review something where there's maybe only one or two contractors, especially that is operating in any one sphere at any given time? And how do you actually monitor and provide that level of oversight that is also required from a precaution? Because again, precautionary is not necessarily a one and done approach. It's not like, okay, you do it at the start, like you said, of the exploration regulations, you get a precaution, okay, it passes muster day one. But again, partly the precaution is what happens when new evidence, new information comes to light. What happens if there's changes to the environment? What happens if something happened? So again, precautionary is an ongoing issue as well, and that would need to be dealt with in the kind of the monitoring context as well.
Very brief point to Ed. I think this highlights really the importance of independent marine science. And we've seen a couple of sort of countries, highlight that point and sort of commit to funding independent marine science in the deep ocean. Because of course, scientists can do great work when they're funded by mining companies and so on, but there is a degree of bias, as to, how the data is used and so on. So it doesn't replace independently funded marine science that does not have a commercial application as such. And so that's one other way, I suppose, to create more independent data about the deep ocean.
Yeah, I think the general issue of how you deal with conflicts of interest is a very important topic that needs to be further addressed, and hasn't been enough addressed actually. But there's a lot of issues with funding, of fundamental marine scientific research as well. There's a lot of leadership that is being needed from states themselves to be able to solve the issues. So there's a lot of things to do. I was wondering actually, since with Robert, we really wanted to emphasize the importance of the precautionary approach, and that's why the chapter was placed really at the beginning of the book, in the global perspective. I think it's quite interesting also to realize through this discussion that, let's say a simple approach, a legal tool that we human design or invented, can have like a lot of, impact on many different angles and topics, including the governance of the International Seabed Authority. It's been a lot under scrutiny the last years, with some states, including the European Union, asking for a reform of the governance of the International Seabed Authority, with the goal actually to strengthen, the what we call the legal order of the ocean, to make sure that international organizations have all the tools possible to implement their mandate and do their jobs, basically. And since this discussion has actually led us to spot like some weaknesses, along the way, which are normal, I would say, because we're in the phase of starting new activities. So there's a lot of questions that are being asked. How do you think this topic of the implementation of the precautionary approach could inform the reform of the governance of the International Seabed Authority? What could be done to actually strengthen the International Seabed Authority and to deal with all the, the different contests and dispute regarding, what constitutes scientific certainty or not? We see it with the moratorium. We see with many, scientists being completely divided on what is, the level of risk and what could be enough or not enough scientific knowledge. So I think it's a nice, pathway towards a very important topic actually with regards to deep sea mining.
Yeah, that's a good point. I think if the ISA was to sort of fully set out how it intends to apply precaution, and if it applies precaution to the full decision-making cycle, then that would certainly feed into, necessary changes at a governance level. So as we said in the beginning, precaution sort of requires you to first have a clear environmental objective, which currently the ISA does not have. Those objectives, of course, need to reflect public opinions and so on. So they need to be arrived at in a sort of transparent and participatory manner. That, of course, means, the governance structures need to be such as to accommodate that public participation and so on, and including the voices of Indigenous peoples and so on. That would require changes at a governance level. Then the idea of the environmental impact assessments being the sort of scientific assessment before there is a value judgment, that would require some changes in governance, in the sense that at the moment, mining applications are being assessed by the so-called Legal and Technical Commission, which is a subsidiary body of the ISA Council that meets behind closed doors. And so while that body doesn't really make decisions, it only makes recommendations to the council. In practice, their recommendations carry a lot of weight and can be a de facto decision. So there is a question about how much the public and even states know about the sort of the reasons, I suppose, for that Legal and Technical Commission making certain recommendations. And one thing that has been asked for was for the Legal and Technical Commission to clearly set out if there are any scientific uncertainties in their decisions. right? So when they are reviewing in the future environmental impact assessments, or they're reviewing applications for mining in the future, they would need to set out, ideally, if there are scientific uncertainties inherent in the assessment, inherent in the application, so that there is more transparency coming out on what is the basis of those scientific and technical recommendations. And then also, when we look at the other end of this of the decision-making procedure, so if mining is approved, then of course we have the monitoring and implementation phase. And so again, there needs to be the capacity, as we already discussed, to actually monitor the environmental impacts of mining, and to be able to review and reassess if things do go wrong. So at the moment, we don't have a good compliance regime at the ISA to identify non-compliance, and it's unclear as to what exactly would happen if non-compliance is alleged by certain parties, but perhaps not officially. If there's are there whistleblowing procedures? Well, at the moment we don't have them. So there's a whole host of sort of governance questions that feed into the full and proper implementation of precaution.
Mm. Do you think I mean, I'm looking from an outsider point of view. The ISA has been, heavily criticized, and there's a lot of worries about deep sea mining activities moving forward with exploitation. The reason why the legal and technical committee is not working on, on welcoming, other stakeholders outside of the realm of the members of these committees, it's mainly due to commercial confidential information. So do you think, all that you mentioned with the governance, I'm actually wondering why there's no tangible proposals to actually support the work of the International Seabed Authority with concrete proposals of reform to strengthen the transparency, to address, these issues of stakeholders, and why we don't see anything concrete being done, because states are being too absorbed by the mining code and they hope to have everything solved by the mining codes, or because there's a lack of understanding about what could be done and what could be fixed, and in a way that could preserve, the importance of the authority for the governance of the international seabed area. I know it's a tricky question.
I think there are a lot of sort of tangible and good ideas for reform within the ISA, but as you say, the ISA council sessions are very much being taken up by developing the mining regulations. There is a time and place for the discussions on governance, and that is probably in the context of the review under Article 154 of UNCLOS. So that article requires the ISA to do an institutional review every 5 years to sort of assess how the whole regime is working in practice. The last and first of such reviews has been more than 5 years ago, so the ISA is overdue. And it remains to be seen whether states will agree or decide in July and August to commence one of those reviews. It's been on the agenda last year, and there's been a little bit of hesitation because the ISA is currently so busy with the mining code. So we'll see if there is appetite for that review now, and I think that's then the time and place for those governance questions.
Just that, I mean, I guess 2 minor points. So yeah, the role of governance overall, I mean, I guess the underlying risk is this idea of what we call regulatory capture. Basically, does the contractor's interests, influence the Legal and Technical Commission? What is the composition of the Legal Technical Commission? Who actually sits on the Legal and Technical Commission? Are they scientific experts? Are they, interest holders? But it also goes right to the top. I mean, the ISA has recently changed, fairly recently, in terms of everything. Their executive director. There's new leadership at the top. So the outgoing Michael Lodge, has been replaced by new leadership. So will that help drive any differences in how things are negotiated? Because often things will get driven from the top, and what priorities are set in. But Aline, and it correctly said, again, everybody's so focused on just getting this mining code. But at the same point, to be fair, is you're dealing with 167 odd different countries. Each one has different interests of themselves, all potentially legitimate. So trying to get 167 parties to agree to anything is a challenge. So to give a little bit of good news, it's hard to get 167 people hard to get 3 people to agree to things sometimes. So to legitimately trying to get 167 different countries, again, from different, and you can have the developed and developing north, the north and the south, again, a lot of different underlying interests without getting to the whole history of negotiating this thing, a lot of different interests on what everything is supposed to look like when it comes to the, mining. And all different underlying, real different underlying issues to this. So again, to give a little bit of good credit, again, they're working, again, they are working trying to get consensus, but getting consensus among that many different parties, 167 out of them, is challenging.
I think a good example would be the UN Convention on the Law of the Sea. I mean, it took 9 years. So,
Yeah.
I mean, with a lot of, different type of topics, but deep sea mining was already a very difficult topic to negotiate already in the 70s. So you can imagine with the 1994 agreement, it was difficult. And now it's, things are getting even more concrete and closer to potential exploitation. So I think there's a lot of tension. And pushing too much the system to go too quickly, it's absolutely non-reasonable. It's impossible to do it too quickly. Otherwise, as we say, you can end up with a bad agreement, and a bad agreement is worse than a non-agreement. So it's very dangerous. Sorry, Aline?
Oh yeah, I just wanted to echo what Keith said. I think what we often see in the media is a sort of a criticism of the ISA not being fast enough and so on. And a lot more could be done, sure. But Keith is absolutely right. I think all organs of the ISA have been working really hard on the mining code and on other questions. And we must not forget that the members of the Legal and Technical Commission are volunteers. They're not paid for the work they do for the ISA. They have normal day jobs, and essentially volunteer their time for the ISA. So I'm sometimes surprised how much the ISA actually gets done. Mm-hmm. So I think sometimes the criticism we see in the media is somewhat unfair.
Yeah, and I think it's something also that is quite unfortunately common, with the bodies that are related somehow, to the UN Convention, because we have the same issue with the Commission on the Limits of the Continental Shelf, with their members that are being volunteers, and with more and more work, 30 years almost of queue for having the submission for the extended continental shelf being examined. So there's a lot of things that could be actually solved if states could support more actually the institution to make sure that they have more means, more tools, more people to be able to work efficiently. So yeah, I do agree. So maybe we can wrap it up, and just like a broad question based on the research that you've made. I mean, you've both been working on deep sea mining since a long time. What type of main legal issues do you see associated with the implementation of the precautionary approach in the years to come? Because there's a lot of things we discussed already, but maybe if you had to pick some of them, what would they be?
So I think one of the key issues at the moment is that the ISA hasn't yet agreed on environmental goals and objectives. So I think it's really difficult to apply precaution properly without knowing where you're going, without knowing exactly what your environmental goals and objectives actually are. So in terms of assessing what protective measures can be justified under precaution, be it a moratorium or a much less impactful or a much less invasive measure, we need to first know what the objective is, so we can then assess whether the proposed measure is effective and proportionate. So I think that's the sort of key challenge for the ISA, to have clearly agreed environmental goals and objectives. If I had to pick one, that's probably the biggest.
Yeah, and I would just echo that in the sense of seabed mining is a nascent industry. It doesn't completely exist. So again, it's trying to figure out how it will actually work. Right now, it's mainly trying to take from land-based mining in terms of the tools and procedures and is that truly even a correct comparator? I mean, it's written in the law of the sea, but again, it's trying to figure out what is out, how do we actually operate this? Is it, do we need to more merge mining with trawling and farming, different operations? And how do we figure out some of these issues and baselines? Because at the end of the day, we still don't know a lot what is found on the sea floor. So trying to establish the basic underlying, okay, what are we actually dealing with down here? We've gone to the moon, and all this kind of stuff. But what are we actually dealing with at the bottom of the ocean? It is, the frontier. We don't know a whole lot. So establishing really clear metrics around and trying to figure out, and say, okay, what is there? What do we not know at what is at the bottom of the ocean? And what are we truly okay with accepting in terms of potential risks and harms of things that we really foundationally don't yet understand, whether it's flora, fauna, what are we okay with not knowing, and what level and what threshold of precaution are we okay as a society okay with accepting?
Yeah, I think it's a really wonderful way also to bounce back on, the scientific chapter that is doing the opening of the book, where the authors actually said in a very simple way that we are still discovering species rather than understanding the functioning of ecosystems. And I think it's a very simple phrase that can sum it up all, in terms of what we say about baseline, impact, decision making, and we see that even the scientists are, still saying that basically we need to understand and not just identify, which is two things that are completely different. It was super interesting. Thank you for your time.